Thank you very much, Chair, honorable members. It's an honor to be here, and we thank you for responding so promptly to our plea, because our plea was made in a state of grave concern about the amendment that we saw passed. I'm Wanjiro Gikonyo. I'm the National Coordinator with the Institute for Social Accountability, which serves as the Secretariat to the Devolution Forum. And allow me just to explain a little bit about the Devolution Forum. We are a multi-sectoral alliance of like-minded civil society networks, organizations, and individuals united for the promotion and protection of devolution and its implementation as enshrined in the Constitution of Kenya. So we are a loose, informal network of civil society organizations, and there are some individuals and like-minded institutions that sit with us, depending on the issue. And I'll leave them for the members who are here present to speak. We have about 200, a membership of about 200 in different parts of the country. We have representation in several of the counties through our membership, because some of our members, like Uraia, Kreko, which is represented here, are coalitions, so that they have members in different parts. So we may be few here, but we have quite a number of institutions on whose behalf we bring forward these issues.
I ask the Devolution Forum to make their presentation. I understand there are one or two members of the committee who may want to make a comment.
I have only one objection, Mr. Chair, and which I think it's better it goes on record, because we have consulted quietly here, but it's better it goes on record. Usually Parliament works by receiving first whatever document they require, whether it's a bill, whether it's a petition, whether it's a report, anything, and we are not allowed to anticipate debate. This is the first constitutional amendment that's coming to Senate from the National Assembly. It is weighty, it's very important. Those of us who are here would like to engage. While engaging with such a very intelligent group, we don't want to just become passive. We want to ask very intelligent questions. The Chair, we cannot ask those questions without postulating or anticipating some kind of a debate. For me, it would be better for us to come here more openly, asking more serious questions, and having even a particular inclination, than to become passive here to listen to them read a presentation and then we tell them, okay, thank you, we've had you, we'll call you again when the report is tabled in the House. If it was myself to make this decision, and I want to persuade my colleagues on the other side, my friends from the forum, it would have been far much better for us to adjourn this meeting without going into the details until the time the bill comes to Senate, which should be along this week or early next week. Then we call you. That is really my plea, Mr. Chairman. Then at that point in time, we can now engage them within the law, but also more. There's nothing that stops us from just receiving their petition, but really we engage now by asking relevant questions. Because as it is now, based on the decision the Chair has made, we can't even ask you anything. Just say, okay, fine, thank you very much. We have had your presentation, now we'll call you again. Then we'll do a double job.
I respectfully disagree with Senator Murkomen on this, because this is a matter that is in the public domain. The public are already commenting on it. It's not like our minds are going to be prejudiced by just asking a question. Personally, the position that I can take is not going to be affected by whether the Senate disagrees with the amendment or not, because it's a position that I must take as a legislator. And therefore, this is a matter of public interest. The public must be allowed to give views. The committee is not going to make any resolution today, because we don't have anything to resolve. We just have to listen. But we must be allowed to ask questions on this, because they are questions. They have thought about it. We need to know what is their thinking, so that it can inform the debate when it comes to the debate. But as far as I'm concerned, the Senate does not have the business of the amendment on the floor of the Senate. And therefore, we are not anticipating debate on business as far as my own interpretation of the standing orders is concerned.
For me, as I said, there will be no resolution per se as to what our position on this matter is. It is we are accepting on the basis of your very proactive actions, as the chairman has indicated, and it is to inform part of the ongoing discourse. And I can tell you for a fact, I know that matter will come before the Senate. So I think, as the chairman said, we will hopefully call you again so that you can find that time. But I see no harm per se in having this discussion in a manner that is not prejudicial to the very proceedings of Parliament in their totality. So I think we will guide ourselves even in our discussion to remain as non-committal in terms of by way of resolution as practically possible. But for me, I think I share in the chairman's view that it's very progressive for Kenyans out there to see this type of issues. And I know you want to engage this committee in further issues around the CDF. I know how active you are in some of these matters. And at the Devolution Forum, the Committee on Devolved Government, Legal Committee, these are some of the avenues of entry into the Senate, particularly around constitutional matters which are extremely weighty. So I will agree to that extent where nothing we will discuss must border towards prejudicing whatever the proceedings of Parliament might be. And therefore, and if necessary, we should be in a position to invite you again to now have a much deeper interaction. And that's when also you'll know some of our positions. I also, in my mind, I've already taken a position. I know many others might have taken a position in their minds, but that is not for us to necessarily divulge today. Finally, we'll have to compile a committee report that will inform, and the committee report can be arrived either by consensus or by voting. And therefore, that maybe will inform part of the discussion on the matter before the Senate more formally. So I see no harm per se in this interaction, in my assessment. If I want now to persuade my brother here to allow that we just proceed on account that this will not be prejudicial, as advised even by the Senate Legal Committee, Secretariat.
Chairman, I think I did personally raise this matter, when I came to the committee and saw the agenda. I agree that already we have discussions informally. I don't think that if you look at all the committee members, we almost know the position of each of us on this particular matter. But that position we hold out there informally. Today, if you look at this petition, Chair, the matter before us could only come to this committee on two accounts. One, either as a petition, and two, as public participation towards a bill. If it came to us as a petition, then that means we would have received it officially, from the House, and the Speaker commits it to the committee. And the first business, obviously, within the committee would be to ask ourselves, what is the subject matter in this, before us in this petition? In this case, it's about a constitutional amendment that has been passed by the National Assembly that is on its way to the Senate. If you look at the standing orders, this is a petition that will eventually be committed to this committee. And therefore, whereas there is no serious objection as to the Devolution Forum presenting before us, but the question is, why would we want to take them through double process, where they have to make this communication today, they present before us, and then we are restricted in terms of engaging with them. And then once the bill comes before the Senate officially, it is committed to our committee officially, then we have to invite them again, because we cannot carry the derivations that we will have today into that process, because this is not, it will not be part of the records that will get into our committee. So to me, it almost appears as if we are engaging in an exercise in futility, because we will still have to invite you to come and make presentations before we engage with you. So, Chair, my position really is that if we could receive the written submissions, then our committee, we retreat back to the Senate. We wait for that bill to come before us. Once it comes before the Senate and it is committed to our committee, we can give the Devolution Forum the first priority to appear before us once the bill is properly seized within our committee. The other aspect is that we could still listen to them. I mean, it's okay, we hear them out, we appreciate, but then we restrict our communication. I mean, we, most likely you will be the only one engaging them, because then you will, once they are done with their presentation, they are like, thank you so much, and we proceed on. But my other question to the Devolution Forum will be, did you have an opportunity to engage with the counterpart committee in the National Assembly that engaged on this matter? And how much, if yes, how much of your contribution was, considered by that committee? But really, Chair, we will be restricted in terms of how we can engage, but we'll leave it to you.
Chair, I just wanted to conclude something, Chair. Just sorry for coming back again. Chair, I'm here. Just one more.
Don't want to give the lady a chance.
Yes, then you can give her. For me, we're actually acting illegally. I was trying to avoid that initially. The only way a committee of parliament can be able to be seized of a petition from any person from the public is when it comes through parliament. What it does, it comes to the speaker, to the clerk, then it's read on the floor of the house, then committed to our committee. Or if it is whatever, it goes through the clerk's office, it comes to the committee. Now there are two things, Chair. Chair, listen, there are two things. Let me say this. There are two things. One, there is no bill for which the members of the public can be able to engage us on. There is none in the Senate, except that is the National Assembly. And we are not an extension of National Assembly. We are the Senate. The only way we can engage properly within the law is when we are seized of that responsibility. Two is that there is no petition or any letter to the Senate that has been given to the Senate that is committed to this committee. So we have done this suo motu. It's like we have received as a committee directly, and we want to engage directly without having the subject matter having been committed to this committee. To me, honestly, we could just do that, like everybody's saying, there's not, everybody's running to the argument that there's nothing in law that blocks us from this, we can engage informally. Why should we engage members of public informally when we have a right in law, and they have a right to engage for the record, and for us to table it in the record? That's really, I don't want us to do an exercise in futility here, and then next week now come and do the proper exercise.
For members of public, they might not understand the procedures of Parliament, and they have a right at whatever level to make their presentation so that Parliament can understand them and also give them an opportunity to engage Parliament. So personally, despite the fact that the bill is not before the House, and of course some of us, we have not even read the bill, that doesn't mean that we should deny members of public or civil societies to make their presentation. Personally, I would feel that, of course, this has gone to National Assembly and it has not come to the Senate. But it is good for us to give them an opportunity so that they can make their presentation. Then once the bill is formally before the House, then we can be able to input whatever they have presented before us. Thank you, Chair.
Thank you very much, Chair, and honorable members. And I really take note that you're concerned about us not expending our effort without a substantive outcome. But I think the fact that we brought ourselves here, and the fact that we believe in public communication, public participation, I think already demonstrates we are ready to engage. We engaged in this process when the guidelines on equalization fund were first published by the CS. We engaged again when it was in Parliament. We are here today, we'll be back tomorrow. As members of the public, we engaged in both invited and uninvited spaces. We create opportunities to engage and we use the formal. The fact that you're bound maybe by legislative limitations, we are not bound. Under the Constitution, we will engage in any mean that is legal. So I'd like to really implore, and I believe I speak for the members, we would wish to have this discussion, share our thoughts, And I believe it will also help forge this relationship, forge the dialogue, and maybe even perhaps inform the agenda. Maybe we'll even improve our memorandum as we come back. So I urge that you allow this exchange to continue.
I've listened to the presentations that have been made by my colleagues, the senators, or members of this committee, and the presentations made on behalf of the Devolution Forum. A letter was written by the Devolution Forum under the signature of Wanjiru Bikonyo, request for an urgent meeting to present a memorandum on the Constitution of Kenya amendment. It was an urgent meeting. I don't want to believe that the request for an urgent meeting was merited in view of the amendments that had been passed by the National Assembly. That letter was addressed to the clerk of the Senate and also addressed to me as the chairman of this committee. And the directive from the clerk's office was that this matter be brought to the attention of the committee for appropriate action. So we are here as a committee addressing this letter properly referred to us by the clerk for appropriate action. And therefore this meeting is perfectly in order. Now for that appropriate action, we are aware of the constitutional provisions and standing orders of these matters. And you may recall that before we even introduced ourselves, I thought that it was important that I bring to the attention of everybody the issues involved as far as the procedures are concerned, which procedures we must also respect. But those procedures do not in any way dilute the rights of any citizen of this country, having access to the Senate, access to the committees. Many letters have come to the clerk, to the speaker. They have been referred to the various committees to deal with as appropriate. As far as I can see, this is not a petition. It's not a petition. It's just a memorandum to be presented. And even if they would not have wanted this meeting, it would have been perfectly in order for the Devolution Forum to have sent this memorandum to all senators in their pigeon halls. It does not mean that when the senator receives it, he keeps quiet until the matter is properly brought before him to go to through the speaker to go to the floor. No. But it must await that before we consider. It's in the public domain, and as senator we have the right to look at it and begin forming our opinion on it. And therefore I would commend the Devolution Forum for having brought this memorandum. But we as senators must also be careful in that, because it's not it has not gone through the procedures properly to be before us, to engage them properly, we don't also want to disclose our positions prematurely. But definitely we as senators, we are entitled as a matter of right to receive the views and to quietly consider those views which will inform the debate when the matter comes before this House. That's my, and therefore, to the extent that participation, public participation is a very cardinal principle in our constitution, and we do not in any way limit that right. And if the participation can take place without infringing on those constitutional things, well and good. And I believe that receiving views, my belief is that receiving views from the public at any time in any forum is their constitutional right. How we deal with it is for now this committee to decide. And this is how we are going to deal with it. I'm going to allow the Devolution Forum to present their memorandum and to explain what their memorandum is all about. We as members, I would really discourage questions or commenting on it at this point in time. Take this to be enlightening ourselves on what the Devolution Forum thinks about this. And I know many members here already have formed your opinion, vis-a-vis your opinion, and let us wait for the right time to come when we can now, you know, the fact that we know their views now, when we call them back, it will not be a wasted effort. We will be able to engage them in a more constructive way, because we have had the advantage, which they have been kind enough to give us this memorandum well in advance.